So I am just getting set up. Come on in. I have great news for you today. I wanted to share my news with you. So I'm just getting set up on two different platforms. So just hang tight while I get set up. But I have some exciting information to tell you today. All right, so I'm all set up and ready. So good afternoon. This is U.S. Immigration Attorney Sharifa Tharpe. I am back, and I'm back from Newark, New Jersey with some great news. I went there to attend my client's interview after a number of years of going through a lot of difficult processes. My client finally decided to come to me and for me to represent that client, and we just got the approval in record time again. So last month I received an approval within 5 months, and this one 10 months. Within 10 months, we went to the interview yesterday in Newark, New Jersey, and we received the decision this morning. So we are just so happy. I'm happy for my client. I'm over the moon because that client had gone through a lot over the years, and now they're getting what they finally deserve. So I am just so happy to share this news with you and show you that the investment that my client made worked out. After years of trying to go it alone, my client was smart enough to understand that help was needed. And that has brought success. So I am just over the moon. And, now I'm seeing my cases, they're going from over a year to they're going, and these are adjustment of status cases where you're applying within the United States. I'm seeing a process of about, 5 months is the shortest time I've seen so far, might get even better. And then this one was 10 months. So everything is moving very quickly, and I'm having a number of other clients that I am planning for over the next few weeks who will have their interviews. So we are looking forward to a lot of success in the future, and I'm really looking forward to helping those clients to finally reach the end of their processes. But so far, so good. We've received wonderful news. Now, I am here to answer your U.S. immigration related questions also. So go ahead, put your questions in the comments. Since this was an adjustment of status case, I would like to talk about that process. So if for those of you who don't know, adjustment of status is the process where you're applying for your own, your permanent residence here in the US. So where you are, you're maybe here legally on status. So in some cases, you may not have maintained your status. You may have overstayed. Or you may even have crossed the border without permission, and just depending on what you qualify for, you could go through the adjustment of status process. But that's where a consultation is going to be very important, because to determine whether you qualify is going to come down to who do you qualify through, what are your circumstances, and how can I assist you to gain legal status here. Now, with adjustment of status, there are two main ways to be able to apply for this. So first, you have to, so either you're in status, meaning maybe you're here on a student visa, maybe you're even here on a visitor's visa, maybe you are here on, maybe you're here on another type of employment-based visa. like an H-2B, and you're trying to figure out, and when you're here on that status, you qualify through an employer, you qualify through a family member, or you qualify through humanitarian means. So when I say humanitarian means, maybe asylum, through if you qualify for the T, that's for victims of trafficking, or the U, victims of crime. So in that case, if you are maintaining legal status and you qualify for another type of benefit, for some of these cases, family-based cases and employment-based cases, you have to have a current priority date, right? So one category is current priority date, along with the fact that you qualify. You can't just qualify out of nothing. You can't just come here on a work visa and qualify to stay and apply for your green card. You have to have a family member, an employer, or some other means that you're adjusting status. Now, in the case that you're out of status, adjustment of status may still work for you. But then we get down to what's going on in your situation. Are you the immediate relative of a U.S. citizen, right? And if you are the immediate relative of a U.S. citizen and you overstayed your visa, then you could qualify. Keep in mind, immediate relatives of U.S. citizens wouldn't be the sister of a U.S. citizen. It wouldn't even be the married child of a U.S. citizen. It's going to be only these three individuals: the spouse of a U.S. citizen, the parent of a U.S. citizen, and the U.S. citizen is 21 and up, or you are the son or daughter of a U.S. citizen and you're under 21 and unmarried. So there is a special exception for these individuals that if you overstayed, then you could still qualify for adjustment of status. If you entered the country without permission, though, you were not inspected at the border, you were not waived in, then you're not going to qualify for adjustment of status, right? So if you're out of status, if you're the immediate relative of a U.S. citizen, then there may be an exception for you. If you are applying for VAWA, so if you have a U.S. citizen or resident spouse, a parent, and you're under 21, or you are the parent of a son or daughter who's 21 and up, and that son or daughter is a U.S. citizen, you could qualify in this case. Now, when I talk about VAWA, are these relatives the U.S. citizen or legal permanent resident? Is this relative mistreating you? If they're mistreating you, then this could be a basis for VAWA, and that's where you should go ahead, get the consultation so we can evaluate whether you can qualify. And then also, in other cases, if you have already received asylum, if you have received the T or the U visa, then or status, these would also apply for adjustment of status, and you could have a history of being out of status and still qualify for permanent residence. So whichever one you qualify for, I've given you the basic information, but you will need to make sure that you do a personalized consultation so that we can evaluate your facts and determine which one could work for you, and then get started right away. So let's see if we have any questions. I think I saw some here. So I'm married and would like to change my name in my passport. My visa is in my maiden name. Will this be an issue? No, so it shouldn't be an issue. Usually, if you are going to change the name in your passport, get a new passport, you'll have to just, of course, make sure you travel with the passport that has your visa in there. Now, keep in mind that the information that I'm giving you is general information. If you are going to take action, make sure to get personalized legal advice, because this is not legal advice. So just keep that one in mind. So T. Tonili, no. So I don't do lives at 9 anymore. It's at 4:30 p.m. Eastern time. So you can always catch me at that time. So just mark that time and you can look out for me around 4:30 p.m. What does it mean by 2-year rule does not apply in a J1? So when you have a J1, there is what's called a 2-year foreign residency requirement that when you're finished with your program, you have to be outside of the US for 2 years before you can come back into the country to change status or to get permanent residence. So in your case, it's stating that it does not apply. I'm applying for adjustment of status. I did biometrics already, but USCIS asked for evidence. After I submitted the evidence, what will happen next? So it just depends on how you responded. And so that's what I'm talking about with the request for evidence. I don't know what request for evidence you got, but a part of making your, I always get this question. Can you as a lawyer make my process go faster? The straight up answer is no lawyer can make your process go faster. However, my cases are moving quickly because I know I can do these cases with a blindfold on. I know all the legal requirements. I can advise my clients. And because of that, the process is efficient and accurate. And we're able to put a good application together. So by the time the officer reviews your application, they don't have any further questions. They're just going to go ahead, schedule the interview. And when we go to the interview, it's pretty much cut and dry because we present such a good case for the officer to review. So when you just file your adjustment of status, I don't know your case, but usually I don't get a lot of requests for evidence in an adjustment of status or my cases because I make sure that from the start, we put a good application together. So another reason why it's so important to get the guidance, because your case, just this request for evidence can delay your case by 6 months. So instead of looking at a 5-month process to a year process to a 10-month process, like my 2 cases that I've won this past month, where they are now going to become green card holders, one in less than 10 months, the other in 5.5 months, is because I make sure that the quality of my representation is excellent from the beginning to the end to present a good case. And so where I find that there are a lot of issues is I'll get calls from individuals saying they filed and now they're about 2 years in, or they're a year and a half in, they haven't heard anything. And that may speak to the quality of their application as well. All right. Has anyone got a 5-year bar and reapply to get back the visa? It's going to be very hard. When you have the 5-year bar, if the 5-year bar has passed, they're always going to be looking at what the previous violation was. Did you work without a permit? What caused you to have that 5-year bar? So, and you may even require a waiver. So your case is a little more complex. So we'd have to understand exactly what happened to determine how to resolve it. But if you're applying, usually, ironically, to get a green card would probably be easier if you qualified than it would be to get back a visitor's visa. Because remember, the green card, if you qualify, then they are going to maybe request a waiver if you qualify for that, and they'll consider the waiver, consider your relatives. But when it comes down to the visitor's visa, it's very discretionary. And when the officer sees that you've had a previous violation, which was very recent, they're not very inclined to give you another visa. Is there any way the process for a child who is married of a US citizen can take less than 12 years? So no, you're looking at 12 years. You'd have to come with a really, really, really good explanation. Generally, you have to wait for that priority date to be current, unfortunately. In what situation would the 2-year rule not apply for the J1? So it just depends. It depends on the type of program you're in. That's a very broad question, and it really comes down to case by case. What What are you coming here to work? What are the terms of your employment? Is there any time span of how long after marriage you can apply for adjustment of status? No, Keish, but it is whether or not I advise you apply. Now it's going to depend on what does your marriage look like. So that's where the consultation and representation is going to be very important. All right. So how can I prove my marriage is real if I'm in the US and he's in Jamaica, other than my marriage certificate? So there are different ways. When I advise my clients, it really comes down to what does your marriage look like? There's not a one size fits all for the evidence. And when I represent my clients, I get to know my clients. I get to know what their marriage looks like. What are they doing as a married couple? For example, when I think I released a video and I talked about those couples that they don't do anything together. I mean, I can't imagine a married couple not doing anything together. You must have some sort of evidence, whether that's good evidence is going to really depend on legal requirements, what is acceptable, what is accepted as evidence by the Immigration Service. But a good start is I get to know my clients and they can tell me based on our conversation what they do as a married couple. And from there, we determine what is going to be good evidence to put on that application. So it really what evidence is included is going to depend on your marriage. That's where it's important to get representation, get legal advice so you can understand what's required of you. One thing you should never do is just submit a marriage certificate, because that is going to cause you to be, it's going to cause your application to be denied. A marriage certificate is just legal evidence. But the most important evidence is going to be showing the bona fides of your marriage. They want to see that you plan to live your lives together. And what do you have to show that, right? What do you have to show that the two of you plan to live your lives together? And I just can't imagine that a real married couple would have absolutely nothing when they're building a life together. All right, so keep putting those questions in the comments. I'm going to be here for a little bit longer to just see if you have any other questions. So go ahead and put those questions in the comments and then I will answer. All right, so I don't see any more questions coming in, so I'm going to call it a day. But today's Friday, so I will be back on Monday. This week has been very, very busy, but I have always shown up at around 4:30 p.m. on Instagram. On YouTube, it was always at 4 o'clock, but I'm a little late today on YouTube. Starting next week, I should be back on track to be able to come back with the topics that I think will be interesting for you, and also to answer your questions. So I'm looking forward. Go ahead, put those questions in the comments and I will answer. So I see, and you're welcome, Kajab. Thanks so much for your time. Thanks everyone for your time. Nikki Sweetness, thank you. And this keeps me coming back when you let me know that the information I'm providing is informative, because that's what I'm here to do, is to give you information that's going to empower you, to give you the ability to seek the legal advice and representation you need. That's what my client did. I was just in New Jersey. Yesterday, you'd see I was in New Jersey. I just finished the interview with my client, And it was a tough interview, but we got through it. And now she's approved less than 24 hours after. And this was not just about paperwork. This was about preparation. It was about looking at the legal requirements, making sure my client was covered, preparing for that interview, and being organized when we went into that interview. And that's how it was for my previous client, who we got approved in 5.5 months. I'm seeing a shorter time, but it still depends on the quality of your petition. Because remember, there are legal requirements behind this. This is not just paperwork. Behind each question is a legal requirement, is a law. And so you have to make sure that you can meet every single one of those requirements going through the process, especially when you have complications, you have complex issues coming up. It's very important to not just pray and file. I heard someone say they just prayed and filed, and that's the worst thing you can do. It's great to pray, but you still do have to make sure that you're taking the actions to make sure it's going to be a successful process. So have a great evening. So let me say, I see one more. How long does it take for a parent to file for a child? So when we talk about child, keep in mind that under immigration law, a child is under 21, right? Under immigration law, not under 18, but under 21. And so right now, it's a good time for US citizens and residents to file for their children who are under 21, because it's going through a faster process for both citizens and residents. So we're looking at, when it comes on to consular processing, we're looking at 18 to 24 months. However, adjustment of status cases, I tell my clients to prepare for an 18 to 24 month process, but my cases, because we put the work in, because we present good applications, complete applications, I am seeing right now, I have a number of cases that are being scheduled 6 months later, 5 months, 6 months after applying for permanent residence. So I am having a very, very busy summer because my clients' cases are moving so quickly. Do you need a lawyer to go into the interview? Great question. No, it depends. Again, sometimes I give my clients the option, no matter what. When I represent my clients, I represent them from the beginning to the end. However, when it comes to the interview, it's going to depend on what your situation is. Are there issues that I anticipate will come up that my client may not be able to even verbalize what issues will come up? They may not be able to explain. They may not even understand the legal issues that may come up in the interview. And that's where my role comes in. If there are issues that are going to come up in the interview, then in that case, I highly recommend, sometimes I do require, if I'm going to effectively represent my clients, I do require them that I attend. But in other cases, I give them the option. It just depends on each client's case, and what are the issues involved, whether my client can be equipped, whether I can prepare them enough to answer these questions. And if not, then I recommend I am definitely there with them to tackle any issues that may arise in the interview. Is it possible for me to get back a visa if there's a violation 5-year bar? It's gonna be hard, very hard. Hi, can you help me with my asylum case? Absolutely, Hassan. But first, schedule that consultation. Let's talk. And then once we make sure that you qualify for representation, we get started right away. The sooner the better, because remember, asylum, you have to apply within 1 year of entry, or it's going to become very hard to get that asylum claim through. Do you still qualify for VAWA if you're divorced from your abusive spouse? Great question. You will qualify if you've been divorced for less than 2 years. So TikTok, clock is ticking, is going by. So make sure that you go ahead and get a consultation. Let's evaluate your case. If you're divorced for less than 2 years, you may still qualify for VAWA. If the child is older than 21, how long? 5 to 7 years if they're unmarried. Is 4 witness letters enough for VAWA? I wouldn't be able to answer that. It really comes on a case-to-case basis. So it's based on a case-by-case basis. What really and truly, when you're attaching evidence, as I said before, one size does not fit all. And I think that's a big mistake when it comes to these applications, is that there's the assumption that if that person did it, it's going to work for you. And that's not going to necessarily be the case, because even abusive scenarios are different. Maybe there were no witnesses, right? Because a lot of abuse, a lot of mistreatment happens in private, and my clients suffer in private. And in those cases where it's private and there were no witnesses, then it's not going to be, we can't check the box that says witness statements. It has to be another form of evidence, and that's going to come down to their circumstances. To get a green card, you must be married. No, there are other ways. I release videos about the national interest waiver, which you could get. You could apply without your employer. If you're coming here to do great things, great important things in the United States, and you have an advanced degree or you have exceptional ability, then you would be able to get the green card that way. Now, with this national interest waiver, it's going to really come down to what are your achievements, what have you done, how can you show your experience, because it not only requires a master's or a PhD or a bachelor's with 5 years of experience, but other types of evidence to back up your level of experience and your goals, and to show that you can come to the United States to achieve an important goal of national importance, something that's going to impact maybe the economy. Doesn't mean that you have to be famous nationwide, but it has to mean that, so for example, if you're a researcher, if you are, advancing you're in somehow in a field that advances technology, then this could possibly qualify you for the national interest waiver. Any asylum case, saw where they said it takes months now. So with asylum, they have updated the policies to allow for those who are, so they go through an expedited process. They will see, so if they're going through expedited removal, they will see an asylum officer, not a judge. That's where they're trying to push it through faster. And if the asylum officer doesn't believe or denies it, then they may go before a judge. So they're trying to expedite it that way. All right, so that's going to be it for me today. Go ahead, join me on Monday. I'll be back on Monday at 4:30 p.m. Eastern Time. Thanks so much for joining me, for all your relevant questions. I'm going to go and just celebrate over the weekend after another great case, after I travel to Newark, New Jersey to attend my client's interview, after all of our hard work, after years of denials. My client is finally going to be a permanent resident and on her way to a path to U.S. citizenship. So I am over the moon, and I hope that you can be next. But let's start with a consultation to make sure you qualify, and then we can get started. Have a great evening. See you.